What you're about to see is Judge David Fleischer at his breaking point. A defendant charged with a serious felony offense is back in court not for trial, but because she keeps violating her bond conditions again and again and again. This isn't her first warning, it's not even her second, and Judge Fleischer has had enough. But here's where it gets complicated. Her defense attorney argues she was just released from jail days ago. The bond conditions were confusing, there were conflicting curfew times between different courts. Judge Fleischer doesn't care. When you're out on bond for a serious case and you pick up a new charge, excuses don't fly. By the end of this video, you'll see a judge make a decision that could keep this defendant locked up and a defense attorney fighting desperately to keep his client out of jail. Let's break it down.
You are on bond for murder, and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This was an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summer.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the...
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received
it looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the magistrate.
I wasn't aware of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that. Yeah, we got you. We'll deal with that one next. But you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No,
Your Honor, if I may.
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, two at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
Judge, there was a conflict. That's why the BVR was submitted. Felony. So the magistrate ordered bond conditions, but the curfew times were not aligning with the felony conditions.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the movie up right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case. Now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor?
She received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you abide by the conditions and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again,
Sure.
this is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder.
Okay, pause. We need to talk about what just happened because this is a masterclass in how bond conditions work and what happens when you violate them. The defendant, Miss Taylor, is out on bond for a serious felony case. We don't get the specifics in this hearing, but the prosecutor mentions it's significant enough that having bond at all is lucky. Now she's back in court for a brand new charge, assault. And on top of that, she violated her GPS monitoring conditions. Here's the legal framework. Under Texas Code of Criminal Procedure, Article 17.4, a judge can revoke bond if a defendant violates the conditions. That's exactly what's on the table here. Her attorney, Michael, is trying to save her. He argues she was only out of jail for 1 or 2 days. The bond conditions were confusing. One court said curfew was 7 p.m. to 7 a.m., another said midnight to 6 a.m. But Judge Fleischer's response? You still have to follow the conditions. Even if they're conflicting, you come to court and ask to fix them. You don't just do whatever you want. And honestly, he's right. When you're on bond, especially for a serious case, the burden is on you to comply. Confusion isn't an excuse. This is about to get intense.
Case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
I don't know, Mikey. I don't know.
And my assumption is we're going to reach out to felony. My assumption is there's a BDR call for that too. So I don't know what the comment looks like, but
I don't know, Michael. I'm going to stew on it for a while. You want to talk about your other BVR? Or wait, hold on a second. Sorry, let me just finish with the arraignments. Give me 2 seconds and then we're almost done.
No problem, Judge.
Good morning, Mr. Randolph. So you're charged with assault and causing bodily injury. You're facing up to 1 year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. One will be appointed to you, sir. All right.
the judge on
We're doing here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer was dispatched to an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain and then grabbed the defendant, and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Didn't corroborate the facts that the complaining witness provided about getting between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah,
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I do never know these people, Your Honor. I was out. I need a public defender.
I'm gonna give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never in danger. Just I don't intend to be in danger either.
All I want my streets safe.
They was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
You
understand?
protect me from these kind of people.
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to
need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there
No. Exercise.
and I'm
the-
running from these people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want,
I just want to also be safe in your community also.
don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be, no drugs, nothing. Enjoying a beautiful day for my mama's funeral. I know no news. I don't know these people.
Listen, I'm going to have you sign a reset. I'm going to have you take your seat in the jury. Yo, I'm not done talking to you. Once you sign the reset, just take a seat in the jury box. I'm going to find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on. You are on bond for criminal mischief. You've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The judge. On April 26, 2025, a law enforcement officer is on patrol and observed a motor vehicle run a red light and make a U-turn, nearly striking another vehicle in Harris County, Texas. Law enforcement officer observed the motor vehicle drive onto the curb of Richmond Avenue and initiated a traffic stop. The defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business parking lot. The law enforcement officer contacted the defendant and observed him to be eating fried chicken. The law enforcement officer asked the defendant why he didn't lower the window, and the defendant stated he didn't have any and continued to eat. The law enforcement officer observed the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. Law enforcement eventually identified the defendant by name and date of birth. The defendant continued to state, "I don't have anything in question about his whereabouts," and standardized field sobriety tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. Due to the defendant, 0 out of 4 on the one-leg stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walk and turn, the defendant did not turn around. He stayed still for approximately 30 seconds. The law enforcement officer explained the one-leg stand, and after the instructions, the defendant began performing the walk and turn. This occurrence happened again after the law enforcement officer tried to explain the one-leg stand another time. The law enforcement officer observed 2 unopened 6-packs of alcoholic beverages that were cold to the touch, and observed an empty fuzzball and a 24-ounce can of Modelo beer and an empty twisted tea of alcoholic beverage. The defendant refused both breath and blood. A blood warrant was signed and executed.
Mr. Juarez, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right?
There's a number here, Your Honor. I'm not unsure if that meant that he did not have a license at the time.
Mind running it, please?
Yes, Judge. Your Honor, he does have an eligible driver's license.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I have ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand?
Hold on. Did you hear what Michael just said? He asked the judge to admonish her. That means give her a stern warning instead of revoking bond. And Judge Fleischer's response? I don't know, Mike. I don't know. That silence is deafening. When a judge says, I don't know, it usually means they're leaning toward the harsher option. Now, let's talk about why this matters legally. Under Texas law, specifically Article 17.09, bond conditions can include GPS monitoring, curfews, no contact orders, and more. The purpose is to ensure public safety and that the defendant shows up for trial. But here's the catch. If you're on bond for one case and you pick up a new case, that's a bond violation under Article 17.4b. The judge doesn't have to give you another chance. They can revoke your bond immediately. Michael is making a smart argument here. He's saying, Judge, this is her first violation on your bond. He's trying to separate the new charge from the GPS issue and frame it as a minor mistake. But Judge Fleischer sees the bigger picture. She's on bond for a serious case, picked up an assault charge, and violated GPS conditions. That's not one mistake. That's a pattern. And patterns don't get second chances.
You are not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand?
Your Honor, if I may,
Yes, sir.
on the first case, the court previously was testing Mr. Warwares 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider going back to biweekly testing?
Yeah. He picked up a serious case. He has alcohol in the car. I mean, he's allegedly consuming while he's driving, you know? I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers, cold to the touch. No, I have to show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail. I don't know what we're going to do when he bonds out, Michael, as far as testing now. I don't know. But
I understand, Judge.
I'm going to order him not to drive as well. I mean, he's got alcohol in the... No, it's not going to happen. Good morning.
Judge, I'm approaching on Victor Jesus Rauda Lopez. And he's got a bond violation report, Your Honor.
Page 10.
Is he here?
He's here, Judge. He's in the jury box.
Speak English?
Yes, he does.
Come up. Come up.
Answer yes or no, sir.
Did you get your GPS device?
Oh, yeah.
Hey, I'm revoking your bond. I ordered you to get a GPS device. You didn't get it. Okay, those are for you. Sorry, Maria. All right. We're going to keep you. The bond right now is, oh God, it's 5,000 now.
I already paid the half.
1,001. Yeah, just raise it up 1,001.
6,000.
It's 5,000 now.
Right.
So I'll just do 6,001.
Okay, Judge. 6.
Mr. Ayler, sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. It looks like you're also charged with unlawful carrying of a weapon. On that one, you're facing up to a year and or a $4,000 fine. Okay.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 50 miles per hour in a 30 mile per hour zone via radar and failed to signal at a right turn. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a handgun on the rear right passenger floorboard. unholstered, and later confirmed to be loaded. Law enforcement officer observed glossy eyes, strong odor of alcoholic beverage, and slurred speech from the defendant. The defendant admitted to consuming 3 alcoholic beverages. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The defendant consented to provide breath and blew a .136 and a .141.
Okay, any prior DWIs?
Yes, Your Honor, out of a different county.
Did it open?
No, Your Honor, it was closed in 2014 with 12 months of probation.
Can you run a full NCIC to see how many there are?
Yes, Judge.
Mr. Ayler, I'm going to find that there's sufficient probable cause to go forward with the case. Also, if you can run his license, please. I'm now placing a restriction on you, Mr. Ayler. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke the bond, put you in jail. No more PR bonds. Likewise, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. I'm sending notice to DPS in Austin. Every single officer in the state will know that if you're driving a vehicle and it doesn't have an interlock, you will be arrested and put into jail. Do you understand?
Judge, it's just the one previous DWI.
Okay, license, what'd you say?
License.
You're also not allowed to drive unless you have a valid license and liability insurance in your name as well. That is a part of your bond conditions. For now, I'm going to have to go to Victoria, sign a reset. You will eventually get with Roxanne for your bond conditions, and after that, you'll be free to go.
It is eligible.
Great. Okay, come on. Mr. Bustamante, I know that there are 2 sides to the story. I get it, right? That's why we have trials. But in the interim, we ask you to do several things. And when you don't, there are serious consequences. Number 1, we ask you to show up. On your first case, you failed to appear just in and of itself, and we had to issue a warrant for your failure. We issued bond conditions on that as well. Those conditions were also broken. You've now picked up a new case. I want you to understand something and listen and hear me clearly. Mr. Bustamante, I want you to listen and I want you to hear me clearly, because what I'm doing now is I'm putting orders of protection on both of your cases. And if you violate these, you are looking at 2 more very serious violation of a protective order case. That in and of itself is the capital murder of misdemeanors. Do you understand? You violate conditions on that, I can have a hearing to hold you at no bond.
I understand 100%, sir, Your Honor.
The only thing I am asking you to do is do not have contact with either of the complaining witnesses in these cases. I don't care if they're relation. I don't care if there's no relation. I don't care who they are. Do not have contact. And when I mean no contact, I mean no contact of any kind. No phone calls, text messages, social media, emails, Snapchat, whatever, maybe smoke signals. No means no.
It's not a problem, Your Honor. It's not a problem.
So this is now an order that identifies both Bustamantes as protected individuals. You cannot communicate with them. You cannot commit an assault, commit an act in furtherance of an offense under section 42.017 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, communicate with a third party to try to communicate with them. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work.
I understand, Your Honor. I got 7 kids, and those are not the oldest ones. I'm a good daddy.
Don't talk to these 2.
I understand, Your Honor.
This order only applies to these 2. Don't use the other kids to try to have contact with these. If you do,
we all live together. Right.
Now you don't.
Right. I go to Mom's house.
Best go somewhere else, because they're going to inform those kids now that you're not supposed to be there or have contact with them.
That's not a problem, Your Honor.
All right.
Except the first one, my daughter, she doesn't live here. She ran away with her husband. Whenever she called the cops, she wasn't even at the house.
I don't,
I'm sorry.
you have contact with them. I'm not asking you much. You've already picked up 2 cases. You pick up a third, I'm gonna blow a gasket.
That's done. You got it.
State, is there anything else?
Yes, Your Honor. There are allegations of drug use to as per reading your analysis.
Okay. You're not to use alcohol, illegal drugs. I'm going to randomly test you. If I find that you're using, likewise, I'm going to revoke these bonds and we'll put you back in. As it stands now, you are a flight risk. I'm not going to give you a PR bond. So what'll happen now is we're going to put you back. I've got your bond set. If you have someone that posts your bond, then you must abide by these conditions.
My daughter, my daughter.
I've given you a lawyer. You need to talk to the lawyer. You have the right to remain silent. Everything you say, they're going to sit there and they're going to type it to use it to prove your guilt. Just don't say anything. I'm telling you what the expectation is. So if you do get out, you don't pick up a third case.
I have a question.
What's the question, actually?
That's the lawyer.
Okay, so, okay.
Okay.
We're good, Judge.
You good? Okay. All right, Mr. Bustamante, you know what's expected of you from now on.
All right, now we're seeing the same pattern repeat with other defendants, and it's clear Judge Fleischer is running out of patience. Look at Mr. Warwares. He was on bond for criminal mischief. He picked up a DWI. Judge Fleischer found multiple open containers of alcohol in the car, cold to the touch, meaning they were recent. His attorney tried to argue that Warwares had been doing well with twice-a-week testing, but Judge Fleischer shut it down immediately. No, he picked up a serious case. He's got alcohol in the car. I have to show you that we mean business. Bond revoked, straight to jail. Here's the legal principle at play. Texas Penal Code Section 49.04 defines driving while intoxicated. But beyond that, under Article 17.4, any new criminal offense while on bond is grounds for revocation. Judge Fleischer said something critical. Me letting you go again when you have multiple violations, it's not going to happen. This is about credibility. If a judge lets defendants violate conditions without consequences, the entire bond system collapses. No one takes it seriously.
For tampering with the government's record, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 26, 2024, a law enforcement officer was on patrol in Harris County, Texas, when he observed a motor vehicle going 82 miles per hour in a 65 mile per hour zone. A traffic stop was conducted. The law enforcement officer ran the plates and came back with no records. The defendant stated he did not speak English. The law enforcement officer discovered a case report was made on March 27, 2025, with the same vehicle in question, displaying a paper plate, but with the matching VIN number of the vehicle, with no record shown on the vehicle. A Spanish-speaking law enforcement officer was informed by the defendant that the defendant purchased the car 3 days ago on Facebook Marketplace and was given that paper dealer temporary tag. The defendant was questioned about the March 27th incident, to which the defendant admitted he was in possession of the vehicle during that incident as well. The defendant then admitted to operating a motor vehicle with a fake temporary tag on the vehicle. The defendant further informed the law enforcement officer that he purchased the plates off Facebook Marketplace and met up with a guy 3 days prior to the incident in a Walmart parking lot to receive the fake plates. The defendant was positively identified by his citizenship card from Peru and Venezuela.
License? Mr. Yepes Ovidio, I'm going to find that there's sufficient probable cause to go forward with your case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. And that is a condition of your bond. If I find that you violate these conditions, I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail, immigration finds you because they sweep it hourly. They will put a detainer on you and you will be stuck like Chuck in there until this case is over with. And then you get shipped off to immigration. Do you understand?
Judge, there's no driver's license information populating for the.
This is an affidavit. This is a promise you're going to make to me that you're not going to drive. I don't care what your excuse is. I don't care what your justification is. If you drive, it's really not going to go well for you.
No te va a ir bien.
Do you understand?
¿Entendido?
Okay.
Sí, señor.
We're gonna have you come up here, swear to us that you're not gonna drive.
Ese documento
After
jurando
that, I'll have you take a seat in the jury box or conditions ready. Have you sign it?
para firmar los dos.
Yes, Your Honor. No, Your Honor. Speak up loud enough for me to hear you. Good morning, Mr. Melchor. You're charged with driving while intoxicated. You have worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that after today, this charge will go on your record. It's going to be there for the rest of your life. If you ever get pulled over, which is going to happen, an officer is going to look up your record. If they see that you have a private DPI and they roll up to your window and they smell alcohol or dope, it's probably not going to go well for you. So what we're doing today, from now on, is a minimum of 30 days in jail. Not to mention a $6,000 supervisory fee. And if you don't pay it, every $100 you owe, you sit 1 day in jail. So we understand.
Yes, sir.
You're giving up the right to a trial, the right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. This is what you want to do. How do you plead to the office of driving while intoxicated? Guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to 3 days in jail. I'll give you credit for the 1 day that you've done. I'm going to suspend your license for 180 days, sir. Do not drive until you get a license. Good luck to you.
Maybe we need keys.
Good morning.
So I'm here on Mitchell Estrada. Gary Tabachman said he spoke to you yesterday on the phone.
Do you have the cause number?
No, cause number in Harris County.
No, but for the other case in
No,
court.
it's they're temporary case numbers, so
I know, but the cause number for the court 11 case, because that'll help us pull it up.
spin.
But that'll work too. What is this?
I have to spin it. 030-604-31. I'm glad Gary spoke to you because he told me.
Blaze, I need your help real quick.
Absolutely, Your Honor.
Can I give you a call? Oh, she pled already?
Not that I'm aware of. On what case are you looking?
Is it Mitchell Estrada?
Yes.
Oh, I thought she had an open DWI. She only has these two out of county.
Two in Lee County. She has no cases here.
Okay. Can I give you a cause number?
Is this Michelle Estrada?
Mitchell.
Yes, I see that.
So she has two out of county cases from Lee County. They're asking for a bond to be set so that she can bond out and go back to Lee County. Because otherwise, essentially, whenever you get picked up in Harris County for a case that's out of county.
Now we're getting into the rapid fire arraignments, and Judge Fleischer is setting the tone for every single defendant. Don't be a danger to my city. That phrase keeps coming up, and it's not just tough talk, it's a reflection of judicial philosophy. Under Texas law, judges have broad discretion to set bond conditions that protect public safety. That's codified in Article 17.15, which allows judges to impose any reasonable condition to ensure safety and appearance at trial. But here's what's interesting. Judge Fleischer isn't just focused on whether defendants will show up for court. He's focused on whether they'll commit new crimes while out on bond. Look at Mr. Randolph's case. He's charged with assault. Judge Fleischer tells him, "I'm going to protect my streets at all costs. You understand?" And when Randolph tries to explain himself, the judge cuts him off. "You're going to say something that hurts your case. Just stop." That's brilliant judicial management. Defendants often incriminate themselves during bond hearings. Judge Fleischer is actually protecting Randolph from himself while also making it clear, follow the rules, or go to jail. This is what effective judging looks like.
I give him a PR bond.
Is there not a, so that's where I guess my confusion is.
She's been in custody. The hold was placed on the 29th, so she must have been arrested here this past Tuesday. And at that point, Harris County told Lee County, hey, we got your person. So Lee County puts the hold.
I'm trying to figure out, so we don't have any charges. Correct.
You do not.
Yeah, it looks like she got taken out Class D. I mean, that's however you do it, Judge. What do you mean?
She has a bail jumping, and I wanted to just run it by you guys and see. One is a bail jumping, and another one is a PCS 1 to 4.
Can I talk to David? I think it's also legit. Yeah.
I've not, probably in the entire time I've had this.
I was appointed on Marvin Avila this morning, Judge.
He's just here on bond.
He's on bond.
Oh.
So I understand that there was magistrate's conditions that were done onto it, but I understand that
All he did was no contact, no weapons, and he's not doing anything now. So hopefully we can either work full-time, get into school, or do something. So he's, doing something.
they did the RIP this morning. The person says that they just called the police to get things sorted out, but that they didn't want to press charges onto it. So the state had asked for no threatening, harassing it. That's what's already on there. And then
I ordered no contact, but have you guys reached out to the complaining witness in this case?
they did it. The RIP's been done. And then the message between Sebastian and them.
Judge, the state's willing to agree to threatening or harassing and to remove a residency restriction.
Okay. Come up.
¿Quieres que le traduzca? Le voy a estar traduciendo lo que diga el juez.
Two things.
Dos cosas.
I want you to understand
Quiero que entienda usted.
that I've had to take in a bunch of people in jail today
Ha arrestado a varias personas en la fecha de hoy,
because they continue to violate the conditions.
violando las condiciones de fianza.
I've already warned you
Ya le di la
about
admonestación
whether you here
tocante
with permission and what the
con las
consequences if you're not.
consecuencias si no sigue las reglas.
I will modify the
Se
conditions
lo voy a modificar las reglas por ahora
threatening or
para que
harassing
no tenga
contact.
contacto amenazante.
But you need to understand what is threatening or harassing. It doesn't matter what you think.
No es lo que usted piensa,
It is what they perceive.
es lo que ellos perciben ellos.
If I go like this, is
Yo
that
voy así.
threatening or harassing?
¿Es amenazante?
It is.
Sí es.
Land you in jail.
Y lo puede estar en la cárcel rápidamente.
Is there a protective order in this case? Yes, there is a protective order.
Hay una orden de alejamiento.
Right, so we'll modify that.
Va a ser modificada.
Mr. Avila,
Señora Ávila,
when people have too
porque la
much
gente
time on
tenga
their
demasiado
hands,
tiempo en su tiempo,
they
en sus
become
manos,
self-destructive.
entonces empiezan a destruir ellos mismos. ¿Qué edad tiene usted?
21.
21.
You're 21 and you're doing
21 años. Y
absolutely,
no está haciendo nada.
that's not gonna work.
No es aceptable.
I want you to be a
Quiero que usted sea una persona productiva, sea trabajando o esté en la escuela.
and I'm going to bring you back with
Y
the
vamos a regresar
sure.
en las próximas semanas para verificar
Do
qué
you
es lo que
understand?
está pasando. ¿Entiende usted eso?
All right.
Está bien.
Steve.
No, todavía no, señor, porque va a firmar las condiciones. Okay. Entonces tome asiento hasta que ellos pasen
Thanks,
sus nombres. Thank you.
We'll modify everything now.
Judge, you ready to go over a few?
Give me 1 second. Let me do all I have
Oh, yeah.
a ton of bail orders. Good morning, Ms. Smith. Ma'am, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with a garden variety assault. Both of those are Class A misdemeanors. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. The officer interviewed the complaining witness on scene and found that the defendant observed the second complaining witness, another woman, and complaining witness 1, her boyfriend, opened the apartment door. The defendant attacked complaining witness 1, leaving visible scratch marks on her chest, shoulder, and hand. The defendant then yelled at complaining witness 2, a stranger who tried to hide in a closet, when the defendant followed her and slammed the door on her toe, causing pain and her toenail to come off. The defendant then went downstairs and smashed complaining witness 1's front windshield.
So we have, I guess, the girlfriend and then just an unknown person.
Yes, Your Honor.
Okay. Ms. Smith, I'm going to find that there's sufficient probable cause to go forward with the cases. I'm now ordering you as a condition of your bond not to have any contact with either of the complaining witnesses and not to be in possession of any weapons. Do you understand?
Yes.
If I find that you violate these conditions, if I find that you pick up any new cases, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes.
You see if there's a protective order that's been issued. If there is a protective order that's been issued on the 27th of last month, I would get to know it. If you do something to violate the protective order, the state can and probably will file additional cases against you. Violation of protective order. It's one of the worst cases you can pick up. So know what you can and can't do. You've got a great lawyer here. Listen to him and he will take care of you. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him and he'll tell you if and when you have to come back to court. For now, we will have you go to Victoria, sign a reset. You will then take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go.
Thank you, Your Honor.
So can you file no contact, no weapons on both of the cases, please? So you are Ms. Martinez. Ms. Martinez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. Okay.
Thank you, Judge. On April 26, 2025, a law enforcement officer observed a motor vehicle fail to slow down as it crossed train tracks, causing all 4 tires to come off the ground and the vehicle to go airborne. The law enforcement officer observed the motor vehicle land, lose control, and nearly crash. A traffic stop was conducted. The law enforcement officer contacted the driver and the sole occupant of the motor vehicle, who he observed to have glossy eyes and a strong odor of alcoholic beverage emitting from her breath. The defendant stated she was just at a bar called the Sugar Room. The defendant stated she had 3 alcoholic beverages. The defendant stated she had chronic back pain but was willing to perform the standard field sobriety tests. A 6 out of 6 was recorded on the HGM, a 4 out of 8 on the walk and turn, a 3 out of 4 on the one-leg stand. The law enforcement officer observed a receipt in the defendant's purse showing she had purchased 8 alcoholic beverages throughout the night. The defendant refused breath. A blood warrant was signed and executed.
Okay. Any prior DWI? Okay.
So, Your Honor, there's no traffic offense stated. He claims that the car went airborne, all dukes of hazard.
Sure.
Yet there's no evidence to support that. I mean, did all wheels come off?
This is a probable cause hearing, right? We're not going to get evidence at this point. You know, I think that there's sufficient probable cause to go forward. Now, it doesn't mean you're guilty, but it's enough to go forward for now. Ms. Martinez, I'm going to find that there's sufficient probable cause, and I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, we will revoke your bond, put you in jail. No more PR. You understand?
I understand.
Because you have a lawyer, we will waive your appearance. You don't need to waste your time coming to court, but you must stay in touch with Mr. Butler, and he'll tell you when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. We'll have you take a seat in the jury box while you get to pretrial services, sign your documents, and then you.
All right, appreciate it.
Good morning, Mr. Marshall. Good morning.
Good morning.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 25th, 2025, in Harris County, Texas, a law enforcement officer conducted a traffic stop on a vehicle going 58 in a 40-mile-per-hour zone. The law enforcement officer made contact with the defendant driver and could see in plain view a pistol and a bag of marijuana next to the defendant. The law enforcement officer detained the defendant and found another bag of marijuana in the defendant's jacket pocket.
Okay. Mr. Marshall, I'm going to find that there's probable cause to go forward with the case. While this case is open, I'm ordering you not to be in possession of weapons. Do you understand? If I find that you do, if you become a danger to my city, it's not going to go well for you. You just had a case dismissed not a month and a half ago, and now you're here again. Don't be a danger to my city. Do you understand? Yes or no?
Yes, sir.
Because you have a lawyer, we will waive your appearance, but you must stay in touch with him and he will tell you if and when you have to come back to court. Don't pick up any new cases. Does he have you said he was driving, right?
Yes, sir.
Can you run him? Does he have a license?
Yes, I'll run it right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
All right, here's what happened with Miss Taylor and why it matters for anyone who's ever wondered how bond conditions actually work. Judge Fleischer didn't immediately revoke her bond. Instead, he said, I'm going to stew on it for a while. That's judicial restraint. He's not making a snap decision. He's considering the arguments, the facts, and the consequences. But let's be clear about what's at stake here. Under Texas Code of Criminal Procedure, Article 17.4, a judge has the authority to revoke bond if 1. The defendant violates a condition of bond. 2. The defendant commits a new offense while on bond. 3. The defendant fails to appear in court. Ms. Taylor hit number 1 and number 2. She violated her GPS monitoring conditions and picked up a new assault charge. Michael, her attorney, made a smart play. He framed it as a brand new case and her first time having any issues on Judge Fleischer's bond. He asked for an admonishment instead of revocation. And you know what? That's good lawyering. He's not denying the violations. He's reframing them as minor and fixable. But Judge Fleischer's hesitation tells us something important. He's weighing public safety against giving someone a second chance. Now, let's talk about the bigger lessons from this entire hearing, because there are several. Lesson 1, bond is a privilege, not a right. A lot of people think, I got arrested, so I get bond. No. Bond is granted at the court's discretion, and if you're charged with certain offenses, especially violent felonies, you might not get bond at all. Miss Taylor is lucky to have bond on her first case. The prosecutor even said so, but the moment you pick up a new charge, that privilege is on the line. Lesson 2, conflicting conditions are not an excuse. Michael argued that the curfew times were conflicting. One court said 7 p.m. to 7 a.m., another said midnight to 6 a.m. Judge Fleischer's response was perfect. You abide by the conditions, and then you come to court and ask to align them. That's the legal standard. Under Article 17.09, if conditions are unclear or conflicting, the defendant's responsibility is to seek clarification from the court, not to just wing it and hope for the best. Lesson 3, judges are protecting the community, not just managing cases. Judge Fleischer said it over and over. I want my city protected. Don't be a danger to my city. I'm going to protect my streets at all costs. This isn't just rhetoric. Under Article 17.15, one of the primary purposes of bond conditions is to protect the safety of the community. Judges take that seriously. When a defendant on bond for a serious case picks up a new assault charge, the judge has to ask, if I let this person out again, will they hurt someone else? Lesson 4, defense attorneys matter. Michael fought hard for Miss Taylor. He offered an out withdraw paragraph 5 of the prosecutor's filing, admonished the defendant, and move forward. He gave Judge Fleischer a way to show mercy without looking soft on crime. That's strategy. And we saw it work in other cases too. Attorneys who know when to argue and when to concede tend to get better outcomes for their clients. Lesson 5, accountability is everything. Look at the pattern throughout this hearing. Every defendant who violated conditions faced consequences. Some got their bonds revoked immediately. Others got stern warnings. But the message was consistent. Follow the rules or go to jail. This is how the system is supposed to work. Bond isn't freedom. It's conditional release. You're still under the court's supervision. And if you can't follow basic rules, don't commit new crimes, wear your GPS monitor, show up for court, then you don't get to stay out. So, what happened to Miss Taylor? Based on Judge Fleischer saying he'd stew on it, my analysis is that he likely revoked her bond after the hearing or set extremely strict conditions for any future release. Why? Because even though Michael made a good argument, the facts are damning. Serious felony case plus new assault charge plus GPS violations equals too much risk. And here's the thing. Judges have to think about what happens if they let someone out and that person commits another crime. If Miss Taylor picked up another assault charge a week later, Judge Fleischer would be criticized for being too lenient. So, he errs on the side of caution. That's his job. As for the other defendants in this hearing, Mr. Warwares, Mr. Bamonte, and others, they're all facing the same reality. Bond violations have real consequences. This hearing is a reminder that the criminal justice system has rules for a reason. And when you're on bond, you're not free, you're on borrowed time until trial. Judge Fleischer runs a tight courtroom. He's firm, he's fair, and he doesn't tolerate nonsense. That's what effective judging looks like. If you made it this far, you just watched Judge David Fleischer handle bond violations with precision and authority. This wasn't just about one defendant. It was about setting a standard for everyone who walks into his courtroom. I want to hear from you. Do you think Judge Fleischer was too harsh on Miss Taylor, or was he right to consider revoking her bond? Drop your thoughts in the comments. And if you want more breakdowns of real courtroom cases like this, where we analyze the law, the strategy, and the human drama, hit that subscribe button. We're at 265 subs and pushing hard toward 1,000 so we can keep bringing you daily content. This is Court Every Day. Real trials, real analysis, real justice. Thanks for watching. I'll see you in the next one. The following content is for educational and legal analysis purposes only. This video examines real court proceedings to help viewers understand the criminal justice system, bond conditions, and judicial authority. All information is sourced from public court records.